The 37th Circuit Court is now in session with the Honorable Brian A. Kirkham presiding. Today is Monday, March 20th, 2023 at 8:36 a.m.
Good morning, Ms. Brown.
Good morning, Your Honor. How are you?
Doing well. And you?
I'm great. Thank you.
You can proceed whenever you're ready.
Thank you. Before the court is Sarah Smith on docket 2015-1125 DP. Ms. Smith failed to appear on May 6th of 2022 for a show cause hearing before referee Bradfield. Currently, her bond is set at $1,344. This is her 9th warrant. Her last payment was June of 2021, and that was a $300 bond. Friend of the court is asking that the next hearing be scheduled March 29th at 8 a.m. before Your Honor.
Ms. Smith, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing. When's the next hearing, Ms. Brown?
March 29th at 8 a.m.
March 29th, 2023 at, well, is it 8 or 8:45? We don't have any at 9.
It's at 8.
8 o'clock a.m.
Yes.
You will get notice of that in writing. Ma'am, are you able to post a bond?
No.
No? Okay. Well, the court does note that it is your 9th bench warrant, and you have not, again, paid for a considerable period of time, for years, in fact, other than being able to collect the bond money previously. What I'm going to do, I am reducing your bond slightly. I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, thank you, ma'am. Ms. Brown, we're getting a lot of reverb on you, so that's why I can't hear some of the stuff you're saying, but it's not your problem. We've had some issue with our speaker.
Okay.
Go ahead when you're ready.
Okay. Now before the court is Charles Witcher, docket 1998-2171 DP. Mr. Witcher failed to appear on March 4th of 2019 for a show cause hearing before referee Fryer. Currently, his bond is set at $6,095. This is his 4th bench warrant. His last payment was a bond that was posted in November of 2021. Friend of the court is asking that his next hearing be scheduled on March 29th at 8:45 a.m.
Thank you. Mr. Witcher, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants that the next hearing be held on March 29, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not.
Okay. Well, the court notes that it is your 4th bench warrant in this matter, and again, that you've not paid in a considerable period of time, for a matter of years, in fact. As a result, the court, I will reduce your bond, but I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
Nope. Nope.
Okay. Court will conclude this matter at 8:40 a.m. You're free to go. Have a good day.
All right.
In this matter, Mr. Hooker, you're before the court charged with civil contempt of court as a result of your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir.
Okay. The court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
I don't think that 5 or 10 minutes before court was fair enough, but there's nothing I can do.
Okay, well, let me ask Mr. Sackrider. Mr. Sackrider, do you need additional time with Mr. Hooker? Or did you get the information you needed to proceed?
I'm ready to proceed, Your Honor.
Okay. Then what we'll do is I'll have Ms. Petrulio, I have everyone. I have Ms. Petrulio, Mr. Hooker, and Ms. Bromley. I'll raise your right hands. We'll have you sworn in, and then we can proceed.
Oh, I'm trying, Your Honor. I got a bad shoulder.
That's fine, just as best you can.
Yeah.
Oh.
All right, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes,
Yes.
Okay, thank you. Ms. Petrulio, you can proceed.
Yeah, this is the case of Victoria Bromley versus Dustin Hooker, docket 2013-3238 DP. Mr. Hooker last appeared before Your Honor on December 21st. At that time, he was found in contempt of court. He was ordered to obtain a job and commence payments the month of January as ordered. He did just have a modification of his order. It did get entered the end of this month, so his charge for this month is a little bit than it will be going forward. But he should have paid $536 this month. He's paid nothing. He's had one prior show cause, one bench warrant, and one contempt finding. There was a sentence of 21 days that you ordered back on December 21st, but stayed that sentence pending his compliance with obtaining a job and making his monthly support obligations. His balance in this case is $11,654.31.
Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Petrulio?
No.
Do you have any questions for Ms. Petrulio?
Yes, I do.
Go ahead.
All right, Ms. Petrulio, can you hear me?
Yes, I can.
So Mr. Hooker's payment amount was lowered.
Yes, it was.
Okay. And has Mr. Hooker provided you with any updated medical information since the last hearing?
I don't believe so. I think everything that we had was current as of December. He did call the front of the court and say that he had a medical appointment with Social Security. I don't know that he had that paperwork. It hasn't been turned in yet. But the physicians that he saw and provided information on said he was able to work.
Did he provide any paperwork from Social Security office?
No. I mean, not updated that said he had the appointment. He called me and said it may not be here in time.
Okay. All right, I have no further questions for Ms. Petrulio.
Okay. Any proofs, Mr. Sackrider?
Yeah, I'd call Mr. Hooker.
Okay, go ahead.
All right, Mr. Hooker, can you hear me?
yes, sir.
Did you hear the testimony of Ms. Petrulio?
Yes, sir.
Was there anything that you disagreed with?
No, like she did say in that, and I did tell you in our meeting that I'm waiting. I just tried to call the SSI lady I've been dealing with and I can't get a hold of her. I left her a voicemail and she said the letter was out. That's all she could say. Obviously I didn't get the letter in time to be able to present to the court to when I see their doctor, because I'm going through all the stuff I have to with Social Security office and that, but trying to do what you guys want me to do as well.
All right. Did you provide any updated medical information to Ms. Petrulio since our hearing in December?
No, I just seen my psychiatrist, I want to say last week, and I was waiting for a letter also, or a couple weeks ago, waiting for a letter coming to mail. You know how the mail is, it's slow right now. As soon as I got any information, I was trying to get it to her ASAP, like I did when Social Security office had called me. I had notified her office as soon as I got off the phone with them.
All right. Are you under any restrictions due to medical conditions?
I'm on a less than 10-pound weight restriction on my right arm, less than 50 pounds total in general right now until they do some more evaluations, because I have broken bones in my chest. I have a broken rib above my heart, and I've been having a lot of problems due to the stress and everything else. I've been having some complications with my left arm, going numb on me. That's why I haven't been driving. I've been having other people drive me around.
Okay. What have you done since December to acquire employment?
I have put applications in, but as soon as I explained to the possible potential job, they're trying to say the word here, possible employer, when I explained all my medical situation, everything going on with court and everything else, I get the response, I'll call you back. Beautiful baby there. Congrats. Sorry, Your Honor.
All right. How many applications would you say you've put in since December?
I have put in everything but McDonald's, and I did not tried them because that requires me bending, twisting, and moving my arm. And as you see, I'm just trying to fight the pain to deal with court.
How many applications would you say that was?
I'm gonna say at least 10 plus. I think if I don't go to jail, if I get my shoulders straightened out, he'd possibly hire me into driving pouring for the record company as a service driver, not as a tow driver, as a service driver.
I didn't hear a number, Mr. Sackrider. Did I miss it?
Like 10, Your Honor. You were talking about.
Okay.
How have you been supporting yourself since the last hearing?
Since December 21st, when we had court, I talked to Miss Bromley and that, and my family's been helping me. Like today being my birthday, I had family send me some money to get me something for my birthday. So I ordered me a watch for my birthday gift, so I could try to set reminders on it to help me remind myself with my court and everything. And Miss Bromley told me how to do it on my calendar when I last talked to her, because I didn't know if she used to do all that for me when we were together.
Okay. You have an ability to support yourself off of your current income?
Right now, I don't have a current income. My friends and family's been helping me the best that they can while I'm waiting to find out if I get approved or not for disability. And then my SSI people said they don't understand why I had not had my disability from when I had my first heart attack back in 2016. And so they went back to the very first time I applied back in 2005 to 17 years. And I'm just needing to see their doctor to go any further with it to find out if they find me disabled or not.
All right. Are you able to pay any amount today from any of the birthday money you received?
I've only got like $7 left out. I only got $25 for my birthday.
You got $25 total?
Yeah, I'm still waiting. Today ain't over with yet, obviously.
Okay.
I mean, I put the word out to everybody as much as they can help me would be appreciated, because I want to be to you guys the best that I can.
All right. Are you receiving any state assistance such as food stamps or Medicaid?
No, I've got Medicaid help, insurance due to, they said that my health insurance won't get cut off due to my heart, and that being a heart patient, you never know what the complications I could have. As for food stamps, I got cut off because they said that they had showed 5,687 or $78, something like that, and 31 cents unclaimed money through McLean's Towing, who I used to work for, and I quit due to health reasons and due to their trucks were beating me down, and they did not want to listen to me as an employee that their equipment was falling apart. So I felt unsafe for me to be driving their equipment and for the public. So I left and been trying to deal with my health since. And it's going downhill more and more.
Okay. Are you currently homeless?
All this stress don't help me any. I've been begging and pleading to see my daughter, and the mother says that my daughter's scared to death of me. I don't see how, when I haven't seen or talked to my children in over a year. January 11th of last year was the last time I seen or talked to either one of them. And the mother don't communicate with me on a regular basis like we're court-ordered open communication. She has removed me as a friend on Facebook. She don't read my messages on Messenger. So I don't know how my kids are doing. And I feel personally that if I can't see my kids, then I'm asking the state to take my rights to my kids and let her new man have my rights. Because that she not let me see them. I don't feel that if I can't see them, why should I have to pay an obligation if I can't see my kids? I'm sorry. She can
Thank
have them with her new man. I'm willing to give up my rights if she's wanting her man to step up to the plate.
All right, thank you. No further questions.
Okay. Ms. Bromley, is there anything else that you'd like to add other than what's stated at the last hearing?
No,
Okay, thank you. And Ms. Petrolio, what was the purge amount that we put in place on the December 21st date?
$500.
Okay,
Yes, it was $414 plus $414 a month plus $500 court cost.
okay,
That's what I've got wrote down here in front of me, Your Honor.
okay. Well, in this particular matter, the court would note that I have heard the testimony today that Mr. Hooker was found in contempt of court back on December 21, 2022, that he was sentenced at that time to 21 days in jail, and the court set a purge amount of $500. The court gave him the additional 2 months to acquire employment or to, again, apply for his Social Security and to proceed on that. At this point, nothing's happened. He's in fact applied for, as he said, 10 different applications he's put in. A person could do 10 applications. They could do that in 1 day, not in 2 months. So the court's not seen any substantial effort in these last 2 months, that he still has not had anything as it relates to his Social Security claim. So the court is going to remove the stay in this case. So that means, Mr. Hooker, you're going to have to report to the Calhoun County Jail this Friday, February 17, 2023, no later than 4:00 p.m. And you'll have to serve your time at that point, or alternatively, you can pay the purge amount of $500 that the court had previously ordered. That will be the order of the court. And we'll conclude this. Yes, sir. Go ahead.
You're saying that if I can get friends and family or somebody to help me pay, say, today, that $500
By Friday, if you can pay the $500, then you don't have to serve the time. That's correct.
Okay, how much time am I facing then, Your Honor?
21 days.
Okay, I wasn't sure if it was 21 or if it was the 45. That's why I'm asking.
Nope, 21 days. Okay, thank you. We'll conclude this matter at 10:31 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Okay. So we're gonna move on to. Just a moment, please. All right. And Gina, just to be sure, you said that the other party was not going to appear for this one, right?
That's correct.
Okay,
And who are we dealing with, Ms. Mouton, in this?
This will be Jessica Ash.
Okay, I wasn't sure if that was. Okay. Ms. Ash, in this matter, you're before the court charged with civil contempt of court as a result of your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charge, ma'am?
Yes, sir.
The court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient time to speak to Mr. Sackrider in preparation for this proceeding?
Yes, sir.
Okay. What I'm going to do is, Ms. Mouton, I'll have you and Ms. Ash raise your right hand. We'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes,
Yes,
Go ahead, Ms. Mouton.
Your Honor, in the matter of Ash versus Ash, docket 2021-2764 DS, the respondent Jessica Ash is before the court for a bench warrant hearing because she failed to appear for an adjourned show cause hearing on October 25th, 2022 before referee Snyder. Ms. Ash is currently ordered to pay $211 per month for current support, $50 on arrears for a total monthly obligation of $264.50 to include service and processing fees. Last payment received on this docket was on November 30th, 2022, in the amount of $37.74 through income withholding. Ms. Ash did post a $200 bond on February 10th, 2023 to be released. This is her first show cause, first bench warrant, and she's had no previous findings of contempt and measure compliance over the last 5 months. Ms. Ash should have paid $1,322.50. She paid $203.88, leaving her a shortfall of $1,118.62. Total arrears on this docket are $3,212.12 through February 6, 2023. Ms. Ash was booked into Calhoun County Jail on February 5th, 2023. She was released on February 10th, 2023, so that would give her credit for 5 days. A friend of the court would like to make mention that Ms. Ash has been referred to the LEAP program twice and has failed to enroll and comply both times.
Stackwriter, do you dispute or contest the testimony of Ms. Mouton?
No, Your Honor.
Do you have any questions for Ms. Mouton?
Yes, did she post a bond? Is that why she was released?
Yes, she posted a $200 bond.
All right, and that's not noted on your sheet, is it?
Yeah, I'm sorry. I sent out your prep sheet prior to her being released.
200. And so how many days credit would she have?
5 days credit.
She went in on 2.5 and was released 2.10.
Correct.
And what address do you have for Ms. Ash for the court notices?
We are being recorded, so is that something we want on the record?
Well, if Mr. Stackwriter wants it, we'll put it on the record, but that's up to him.
Just the street address or the street name.
Whittier Avenue.
All right, thank you. I have no further questions.
Okay. Any proofs, Mr. Stackwriter?
Yeah, I'd call Miss Ash.
Okay, go ahead.
All right, Miss Ash, can you hear me?
yes, sir.
All right. Did you hear the testimony of Miss Mouton?
Yes, sir.
All right. Is there anything that you disagreed with?
What, sir?
Is there anything that you disagreed with from her testimony?
That LEAP program, I wasn't aware that they sent that through the email. So I was not checking my email. That's why I was not applied with them, because I was not aware that they sent it through email. I was waiting for a letter in the mail.
Okay. Ms. Mouton testified that this is a support order with Roy Ash. Were you aware of that support order?
No,
Okay. How many children do you have with Roy Ash?
3.
All right. Do you have parenting time with those children?
He's not allowing me to see the kids. I have tried multiple times. So no, at this moment.
Do you have a parenting time or custody order with Mr. Ash?
No,
Okay. She said that you failed to appear on October 25th, 2022 show cause hearing with the referee. Were you aware of that hearing?
No, sir.
All right, did your address change?
No, sir.
What street do you live on?
Whittier?
All right, and you never received notice of that hearing?
Nope. The only paper I received that they were auditing my taxes for child support. That's the only paper I received.
Okay. She testified that you posted a $200 bond to be released from jail. Is that correct?
Yes.
All right. Would you be willing to participate in the LEAP program?
Now that I know it's through email, yes, I would.
She said you were referred twice. Do you recall being referred twice?
No, sir. Just once.
All right. Says here last payment was on November 30th, 2022 in the amount of $37.74 through employment. Where were you employed?
Myers at the time.
All right. Do you recall how much you were making at Myers?
I want to say probably 12 something an hour, somewhere around there.
Okay. What happened? Why did you leave employment at Myers?
It wasn't my choice. It was their choice. They said that I failed my background.
All right. How long had you worked at Myers?
A month.
1 month. All right. How have you been supporting yourself since that time?
Right now through family and friends.
All right. Have you been looking for employment?
Yes, I have been on Indeed. And
All
I've
right.
walked in to the stores I can walk to.
How many, approximately, how many applications would you say you fill out per day?
Well, just between the time me and you talked now, I filled out 25 applications on Indeed.
So you did 25 today?
Yep, on Indeed.
How many would you say that you've done since you were let go from Meyer on, just say December 1st?
Oh, wow, a lot. I mean, literally a lot.
Like how many?
About 100 or so.
Okay. And are you getting any interviews?
No, sir.
And what are they saying to you? Why not?
A lot of them is because I don't have a GED. Also some of them, when I mention my medical background, they say I'm a liability.
All right, let's start with a GED. Have you made any steps to obtain your GED?
I've tried looking online. I was just told not too long ago that the library has a school attached that they might be able to do a night schooling for me.
Millerstone.
Okay. And what's your highest level of education?
9th, maybe?
9th grade?
Yeah.
Okay. And then you stated what was your medical condition?
I have seizures, depression, anxiety. I'm on a handful of different meds right now for other stuff.
All right, that makes it difficult for you to find employment.
She's got sciatic nerve in her back.
Yes, sir, it does.
Hold on a second, Miss Ash. I know there's somebody that's talking to you in the background. We're only taking testimony from you, so I don't want to hear from them.
All right. So yeah, if they could not talk in the background, Miss Ash. What's your medical condition? My apologies.
I have seizures, depression, anxiety, and a handful of other problems I'm taking meds for.
All right, do you have a driver's license?
No, sir,
Why is that?
because of my seizures.
Okay. All right, what assurances can we give the court that you're looking and you're going to obtain employment in the future to start paying on this child support order?
I can try to put some down on the first to start paying on it. But other than that, I'm still looking for a job. As soon as I get a job, they'll be known.
How much could you put down on the first?
50 maybe.
50, and where would you get that money?
It'd be through friends and family.
All right, are you willing to put your $200 bond towards your child support obligation? And if you're unsure, you can say you're unsure.
Unsure at this moment.
All right, is there anything else you'd like to tell the court? All
No, sir.
right, thank you. No further questions.
Okay. Ma'am, you stated that you had, were looking at and looking into your GED. But you mentioned only that you're talking through, public schools and that they might be able to give you some night school or night classes, et cetera. I take it then that you've only looked on that one occasion. Is that correct?
No, sir. I've actually been trying to look online too, but I keep getting online. They keep sending me to colleges, but I wasn't aware of the school hooked to the library up until just recently.
Okay. But you haven't, other than that, and basically being referred to various colleges, you've only basically done, basically that. Is that correct? You've checked online and that's it?
Yes, sir.
Okay.
I will be looking into that school that's hooked to the library because I really do want to get my GED.
Okay. Anything else, ma'am, that you would like me to be aware of?
No, sir.
Okay. Well, the court will make the following finding in this case. In this matter, there is an arrearage in excess of $3,200 in this particular case that Ms. Ash was employed briefly. Myers back in, I believe, last date was 11/30/2022. And apparently when she was trying to hire in full-time, she failed the background check and as a result was not hired in on a permanent basis. She has put in a substantial number of applications since December 1 of 2022 to acquire employment. So the court appreciates that effort. She's stymied by the fact that she doesn't have her GED. And apparently that is something that she's recently done and looked into, notwithstanding the fact that obviously she needs that. I will tell you that there are places that are hiring, even if you don't have a high school education, for instance, Denso Manufacturing. I know, for instance, they are hiring individuals without the high school diploma nor GED. And there are other places in the fort, I believe, that are doing that as well because they simply need people.
Okay.
She stated that both of the applications she's done online, which clearly are very easy to do. I mean, you post it and you can do that within a matter of minutes. She has previously been referred to the LEAP program and stated that her problem was that they notified her by email and that she didn't know that. She thought it was going to be by mail, and that is the reason she did not comply on both of those prior occasions. She testified that she has not seen her children, but there is no order in effect at this current time. She's not pursued apparently any action to have parenting time with them. But notwithstanding that, again, the court would note as well, she has not previously been held in contempt of court. She has various medical issues. She says as far as the seizures that keep her from acquiring employment, but she doesn't have any, she's not presented anything to show that she is prohibited from employment or she is restricted from employment by any doctors or anything of that nature. What happens, the court will, in this matter, find that she is in contempt of court as she's not made a good faith attempt at compliance. She's failed to refuse to comply and as a result is in contempt. What the court is going to do is the court is going to, this is your first offense, the court is going to sentence you in this matter. You've had credit for 5 days. The court's going to sentence you to 10 days in jail with credit for 5 days served. I'm going to suspend that jail time so that you don't have to go to jail, ma'am. I'm going to suspend that and bring you back in. Smooton, about 60 days. When would we have, I don't know, when Mr. Sackrider's back again in April, just as soon have him on it because he's done this part of it. When is, I don't have that schedule in front of me.
He would be back with us April 19th.
Why don't we do that? Is we're going to suspend the time to and have the review hearing on April 19. So Ms. Ash, you'll have to be back on that date. The court is going to order you into the LEAP program. I'm going to want to see at that time, are you complying? Have you been through the LEAP program, et cetera? If you do, the court can continue the suspension or vacate the sentence at that time. It's up to you. Court will further forfeit the bond previously posted in this matter, which will be applied towards the arrearage. Anything else, Mr. Sackrider, before we conclude? You're muted, Mr. Sackrider.
You need to see about the $71.
Sorry about that.
Okay. Anything else?
No,
Okay.
nothing further.
Ms. Mouton, anything else?
No, Your Honor.
Okay, that will be the order. Then we'll see you back on April 19th, and hopefully you've got some things resolved and you've been through the LEAP program, and then we'll reconsider the sentence at that time.
Okay, thank you, sir.
Thank you. We'll end this matter at 10:49 a.m. You're free to go. Have a good day.
You too.
Okay, we got one more here.
Is Ms. Cochran the respondent, Ms. Mouton?
No, the respondent is Mr. Morris.
Mr. Morris, okay. Okay. Mr. Morris, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. I'll ask you, Mr. Morris, I see that the camera's moving that. I don't know if it's just your camera. Are you driving?
Oh, wait, he's.
You're muted. You have to unmute, sir. Mr.
Yep,
Morris,
there you
are you driving?
Yes, I am.
Okay, I don't want you driving during the hearing. I don't want to be distracted, so
Yep.
you're gonna need to pull over so that we can have the hearing.
Yep, I'm pulling in the driveway here in just 1 second, sir.
Okay.
Alrighty.
Okay, good. Don't want any accident or anything. Mr. Morris, as I stated, you're before the court charged with civil contempt of court. Court has appointed you to, or appointed Mr. Sackrider to represent you. Have you had sufficient time to speak to Mr. Sackrider in preparation for this hearing?
Yes.
And Mr. Sackrider, you're muted. Are you ready to proceed?
Yes, Your Honor.
Okay. What I'm going to do is Ms. Mouton's previously been sworn. I'll have Mr. Morris and Ms. Cochran. I'll have you each raise your right hands. We'll have you sworn and then we'll proceed.
Okay, please unmute. Okay. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Yes.
Okay, thank you. Ms. Mouton, you can proceed.
Your Honor, in the matter of Cochran versus Morris, docket 2013-1524 DS, the respondent Larry Morris is before the court for a bench warrant hearing because he failed to appear for a show cause hearing before referee Nuts on November 12, 2021. Mr. Morris is currently ordered to pay $999 per month for current support. Arrears repayment is $499.50 per guideline, for a total monthly obligation of $1,502. Last payment received on this docket was on October 21st, 2022, in the amount of $452.40. Mr. Morris did post a $500 bond on February 3rd to be released from Calhoun County Jail. This is his third show cause, fourth bench warrant, and he's had one previous finding of contempt. I did measure compliance over the last 12 months. Mr. Morris should have paid $18,024. He's paid $452.40, leaving him a shortfall of $17,571.60. Total arrears on his docket are $33,371.14 through January 31st, 2023. Mr. Morris was booked into Calhoun County Jail on February 2nd. He's released on February 3rd, so that would give him credit for 1 day, and he's had no prior jail sentencing.
Okay. Mr. Sackrider, do you contest or dispute any of the statements made by Ms. Mouton?
I do not.
Okay, do you have any questions for Ms. Mouton?
Has there ever been a referral for a LEAP program?
There has not.
All right, would you be willing to do that in this case?
I have no problems with a LEAP referral. Mr. Morris did report that he will be starting employment in 2 weeks. But I have no problem if that's something he wants to follow through with.
Okay. All right, thank you. No further questions.
Okay, any proofs, Mr. Sackrider?
Yeah, I'd call Mr. Morris.
Okay, go ahead.
All right, Mr. Morris, can you hear me?
Yes, sir.
All right, did you hear the testimony of Ms. Mouton?
Yes.
Was there anything that you disagreed with?
To a certain extent, yes. For the mere fact that I had Macy for 3.5 years for every other weekend, that was not documented through the courts. That was through us. And she has not been in daycare for over 5 years. That has also been on my child support as well, that I've been paying towards. I know I haven't made a payment recently, but prior to this, I was paying.
All right. How many children do you have with Stephanie Cochran?
1.
And were you aware of the support order that's in place since September of 2018?
Yes.
All right, and that support order says it's $999 per month. Were you aware of that?
Yes.
Okay, and you said you had parenting time with the child with Ms. Cochran?
Yes, we had original court orders from back when she was a newborn. For it was 2 days a week, every other week, or 2 hours at a time. It was standard visitation.
All right, when did that stop?
That stopped probably when she was 1.5 years, 2 years old. There was a lot of things that were being caused by Miss Cochran in my life that was affecting other things that was going on in my life. And I chose to walk away and chose a different path. And I came back in her life, and I had her every other weekend for almost, it was 3.5, almost 4 years, up until beginning of 2022.
Okay. All right, it says here your last payment was October 21st of 2022. Were you employed then?
Yes, I was.
Where were you employed?
I was self-employed by myself.
All right. And what kind of work did you do?
Construction.
All right. Are you still self-employed?
Not currently.
And when did you stop working construction?
I want to say November of 2022.
Okay. And how have you been supporting yourself since that time?
Hanging on to every last little bit I got.
Okay. Ms. Mouton testified that you have a job lined up in approximately 2 weeks. Is that correct?
Yes, it is. I got a job lined up. I'm going back to my old employer at Crispin Constructors as a master finisher, concrete finisher, in the union. I'll be making $30+ an hour with full benefits.
Okay. And when did you contact them for employment?
I contacted them, it was about a week ago.
Okay. And they said that they would hire you?
Yep.
Are you
Yep,
willing
I'm
to
just waiting on my paperwork from the union hall to get that filled out and sent back to them.
All right. Are you willing to have income withholding set up for your paychecks?
Yeah. Yep.
All right. Says here you posted a bond. Did you post a bond in this matter?
Yes, I did.
That was $500.
Yep. And that can get contributed right to child support if need be.
Okay. All right. Anything else that you would like to tell the court?
I'd like to get child support somewhat readjusted and visitation readjusted. I don't know if I can do that here or if I got to file the motion separately.
Yes, you'd have to file a motion separately. All right. I have no further questions, Your Honor.
Okay. Sir, what, you were self-employed up until sometime in November of 2022, and you left that self-employment. Why did you leave your self-employment at that time?
Me and my fiance started a construction company and I got too stressed out. I got too overwhelmed and it was affecting my life.
Okay. And then,
mentally.
and then basically for the last 3 months or 2.5 months, you didn't seek any employment until just about a week ago from your former employer. Is that correct?
Correct.
Okay. During the time that, how long were you self-employed, sir?
Self-employed for, I'd say 3.5 years.
Okay. And during that time when you were self-employed, did you have income coming in?
I did. I was making about $500 a week myself.
Okay.
And the rest of it went back into the business.
Okay. Anything else that you'd like me to be aware of, sir?
I think I pretty much said everything. Just the fact that I had her for almost 4 years and then she got yanked from me.
Well, in the 4 years, is that when you say you had her, well, you had parenting time on the alternating weekends, as you stated?
Yes, but it was not through the courts. It was through me and her.
Okay,
So
well,
it wasn't documented.
yeah, I will tell you regardless is if the support is set on a base on the fact that a parent would have that standard parenting time. So again, your support would not have changed simply because you had her on those weekends, unless the order provided that you didn't have any overnights. And then that would, again, it might affect it in some way, but it's just like now where you're saying you want to adjust it. If you want to adjust support, you have to file a motion to do so, because there's no way for the court to know you want to change it unless you file something.
Right.
Okay. Anything else you'd like to tell me, sir?
No, sir.
Okay. Ms. Cochran, what would you like to say?
His support is ordered for no overnights as of right now, because he is not ordered any overnights.
Okay.
So that was a 0, and we did make a mutual agreement back in 2018 to bring Macy back around and let him start having time with her. He had her from 2018 to 2022 of May, every other weekend. So I think it started in September of 2018 to May of 2022 is when he started doing every other weekend with her.
Okay,
So he is correct. There was no overnights. And we just took it upon ourselves to be mutual friends and do what was best for our daughter.
okay.
Thank-
Anything else, ma'am?
Not at this time. He does have me blocked on all forms of communication.
Well,
He didn't.
we won't deal with that today. You can deal with that through the court. If you have communication issues, you can file a motion and the court would consider it at that time.
I'll
Absolutely.
take care.
Okay. Well, in this matter, the court will make the following finding in this case, that Mr. Morris had been employed, self-employed for a period of time and for approximately 3.5 years up through November of 2022. As he stated, he was making $500 a week, and there were other monies that he was making, but it was going back into the business. Court finds therefore he did have the present ability to pay and was not paying in this particular matter because his arrearage is in excess of $33,000 in this particular case. Court does note, as he states, he did have some parenting time for a period of approximately 4 years in alternating weeks, notwithstanding the fact that the order of support had him at 0 overnights. And that's unfortunate, Mr. Morris, but you should have filed a motion at that time. You could have had your support amount adjusted and you didn't do it. And the court can't guess at those facts. So you have to let us know and take action. But notwithstanding that, he did have income and money that he was making at that particular time. As a result, the court will find that he is in contempt of court because he had the present ability to pay and he did not pay consistent with the order of support, which he was well aware of in this particular matter. What the court will do, is there anything you'd like to say, Mr. Sackrider, before sentencing?
Yes, I would just like the court to take into account any previous jail time served, the bond that he posted of $500 being forfeited to the arrears, and the fact that he testified he does have an employment opportunity in 2 weeks with the Finishers Union through Chrisman Constructors. And so we would ask that any sentence be suspended or that a purge amount be set so that he can remain out of jail. Thank you, Your Honor.
Okay. Well, the first thing the court is going to do, the court will forfeit the bond previously posted in this matter. Ms. Cochran.
I don't want him going to jail.
Okay. Thank you. Well, what the court's going to do is the court is, at this point, the court is going to sentence you to 14 days in jail, sir, with credit for 1 day served. What I'm going to do is I'm going to suspend that jail sentence, though, meaning it's in place, but you're not going to have to go to jail. And what we're going to do is I'm going to reset this matter for till April 19, 2023 at 8:00 a.m. And that will give you time to, again, get the employment that you're stating that you have in this matter. And that'll give the court that time to see if you've complied and you've paid during the interim. If your support is going to, you have a right to change and modify support by filing a motion yourself. You can get that from the Calhoun County Clerk's office, file an improper motion and proceed if you think that should be modified. And if you're having that particular pairing time, you can get it modified. Likewise, it sounds like Ms. Cochran has been reasonable in this matter. There's always an opportunity that you can, again, modify or eliminate some of the arrearage if you choose to by agreement, if it's owed to Ms. Cochran as opposed to the state of Michigan. If it's owed to the state, then you wouldn't be able to modify that unless you go through the process. So what that'll do is it'll give you approximately 2 months, sir, to show the court that you're going to comply with the order, or you're going to take action, comply and take action to modify it. So it's up to you on what you do. If you do nothing in that 2 months, then be prepared to go to jail when you come back, okay?
Yes, sir.
Okay. That will be the order of the court. We'll end this matter at 11:08 a.m. You're free to go.